Welcome to Module 8 of Private Lending Law course. In this final module, we bring everything together by looking at foreclosure through a national lens focusing on process types, borrower defenses, and strategic considerations for lenders operating in multiple states. This high-level overview will help you approach foreclosure with a more informed, proactive strategy. Foreclosure isn't a one-size-fits-all procedure. It largely depends on the jurisdiction. Judicial foreclosure requires court involvement. That means the lender must file a lawsuit, and the process ends with a judge's ruling before the property is auctioned off. On the other hand, nonjudicial foreclosure allows lenders to bypass the courts entirely if a power of sale clause exists in the deed of trust. Then there are hybrid states where the method depends on specific loan terms or borrower actions. Understanding these distinctions is key to managing risk and timelines. Lenders operating nationally must adapt to each state's rules. For instance, Texas and Georgia are lender-friendly with their fast, non-judicial processes. Meanwhile, judicial states like New York and Florida can significantly delay foreclosure proceedings. Some states like Michigan offer flexibility, using either process based on a situation. U.S. territories tend to favor judicial procedures, but may have unique statutes you'll want local counsel to explain. Mapping out these differences helps you build a smarter lending operation. Timeline matters especially when you're managing multiple loans or dealing with investors. Judicial foreclosures may take anywhere from half a year to several years, especially when courts are backed up. In contrast, non-judicial foreclosures can move quickly, sometimes wrapping up in as little as 90 days. But speed isn't everything. Don't overlook redemption periods, which vary wildly. Some jurisdictions allow borrowers up to a year post-sale to redeem the property. You'll also need to factor in delays from borrower lawsuits, bankruptcies, or government-imposed moratoria. Borrowers don't always go quietly, and they don't have to. Common defenses include equitable claims like unclean hands, where the lender is accused of misconduct, or dual tracking, where the lender moves ahead with foreclosure while also reviewing a loan modification. Others may argue the lender mishandled loss mitigation efforts. And of course, bankruptcy is a powerful shield automatically pausing foreclosure under the federal automatic stay rule. These are not merely delay tactics, they require thoughtful, proactive planning. The best defense is a great offense through documentation, diligence, and jurisdictional knowledge. Be sure your team is following every procedural step to the letter, especially notice requirements. Maintain thorough records of all borrower communication, especially related to loan modifications or workout attempts. And when litigation is likely, work with seasoned local counsel who understands the nuances of that particular state's laws and court system. National lending demands strategy. Tailor your underwriting based on the ease or difficulty of foreclosure in each state. If a state has long judicial timelines, you may want stricter criteria or larger reserves. For higher-risk borrowers, favor jurisdictions with streamlined non-judicial processes. And don't forget, compliance builds scalable systems to manage legal differences and ensure that your foreclosure processes can expand with your portfolio. Part of being a strategic lender is educating your clients, especially when things go wrong. Help them understand not just the process, but the potential cost and duration of foreclosure. Discuss legal risks like contested foreclosures or borrower bankruptcies. Sometimes, the best strategy isn't foreclosure at all. Alternatives like deed in lieu, short sale, or note sales can save time and preserve value. The right attorney can make or break your foreclosure timeline. Don't just ask about cost, ask about experience, efficiency, and how many cases they handle. Their approach should align with the state's process, judicial or non-judicial. Most importantly, make sure they offer consistent communication, track compliance closely, and are equipped to handle litigation if it arises. With the right understanding of foreclosure timelines, defenses, and strategy across jurisdictions, you're positioned to minimize delays and maximize recoveries. Foreclosure is complex, but with the right systems and partnerships in place, it can be managed with precision. Thank you for joining us in Foreclosure Law Across the United States course.